Let me ask you a serious question. What happens to your house, your savings, your car, or even your online accounts if you die tomorrow and you don't have a will? Most people think their family will just figure it out. But the truth is, they won't. The state will. When someone dies without a will, the law doesn't wait for emotions. It follows strict legal rules, and sometimes, that means your property goes to people you never intended, while your loved ones are stuck in a legal maze called probate. So today, we're breaking it all down: what really happens when you die without a will, how the probate system works, and most importantly, how you can protect your family before it's too late. The legal term for dying without a will is called intestate. And when you die intestate, it's like handing your entire estate to the government and saying, you decide who gets what. Here's what happens: the moment you pass away, your bank accounts are frozen. Your house? Locked in legal limbo. Your belongings? Untouchable. Your loved ones can't simply take over, they have to go to court. A judge appoints someone, maybe a relative, maybe not, to act as the administrator of your estate. This person now decides how your property gets handled, all under court supervision. No will means no clear instructions, no guaranteed fairness, and no way to stop distant relatives from showing up with claims. Yes, it happens more than you'd think. You might assume your spouse or kids automatically inherit everything, but that's not always true. Every state has its own intestate succession law, a formula that decides who inherits first. Usually, it goes something like this: if you're married, your spouse and children split your property. If you have no children, your spouse gets it all. If you have no spouse, it goes to your parents. If no parents, your siblings. And if there's no one left, the state takes everything. It's called escheat, meaning your property goes to the government. So think about it: if you wanted a close friend or a charity to inherit something, tough luck. Without a will, the law doesn't care what you wanted. And now, let's unwrap how the probate process works when there's no will. Someone, usually a relative, files a petition in probate court. The court appoints an administrator to manage your estate. All your assets are identified, valued, and inventoried. Your debts, taxes, and final bills are paid. Whatever's left is divided based on state law, not your wishes. Sounds simple, but it's not. Probate can drag on for months, even years, especially when there are family disputes or missing documents. And probate isn't free. Attorney fees, court filing fees, appraisal fees, all come straight from your estate. By the time the process ends, your heirs may receive much less than you intended. Let's be honest, probate isn't just expensive, it's emotionally draining. Families already dealing with grief suddenly find themselves stuck in endless paperwork, hearings, and legal language they barely understand. And here's something most people don't realize: probate is public record. That means anyone can see how much money you had, what you owned, and who inherited it. Your family's private matters become part of the public file. Probate turns personal loss into public drama. And it's the last thing your loved ones need while mourning your loss. Let's take a few real examples. When the musician Prince died in 2016, he had no will, despite being worth over $150 million. His family fought in court for 6 years before the estate was finally settled. Millions were lost to taxes, lawyers, and fees. But this doesn't just happen to celebrities. Everyday families go through the same pain: siblings arguing over property, second spouses fighting with children from previous marriages, all because there was no clear plan. One document, a simple will, could have prevented it all. So, what can you do right now to protect your family? Start with a will. A will is your voice after you're gone. It tells the court who gets what, who handles your estate, and who cares for your kids. It doesn't have to be complicated. You can write one with the help of an attorney or through verified online platforms. What matters most is that it's clear, signed, and updated. Here's a tip: update your will after major life events, marriage, divorce, birth of a child, or buying a new home. An outdated will can cause as much confusion as having none now. If you want to take your protection even further, go beyond the will. You can create a living trust, which allows your property to pass directly to your heirs without probate. You can also set up joint ownership, transfer on death accounts, and beneficiary designations for your assets. These tools save your family time, money, and emotional pain. And they keep your affairs private, away from the public eye. Estate planning isn't just about money, it's about peace of mind. Here's the truth: death is something we can't control, but what happens after, we can. Dying without a will leaves behind confusion, cost, and conflict. But dying with a plan leaves behind clarity, care, and comfort. So don't wait for someday. Take one small step today: write your will, talk to your family, and make sure your wishes are in writing. Because in the end, estate planning isn't about death. It's about love. It's about protecting the people who matter most, even when you're not around. If this video helped you understand how probate and wills really work, don't forget to like, subscribe, and share this with someone you care about. This is Law Unwrapped, where we make the law simple, powerful, and real.